SJC-12751, Commonwealth versus Kelly D. Ridley, Jr.
Okay, Attorney Caddick, good morning.
May it please the court, Elizabeth Caddick for Kelly Ridley. This was a 10-day trial in which the only defense was voluntary manslaughter. It was a reasonable defense where the evidence was that at a party with a lot of drinking and a lot of fighting, the defendant was provoked by multiple people, in particular David Gonsalves, where his short height and small stature were mocked, his manhood was questioned, he was told he didn't have it in him to fight, he was called little man, little boy, and at one point he threatened to get a gun, which he didn't get, there was no gun, but he was mocked then and said, you don't have a gun, you don't have it in you, you're not going to do anything. And so he armed himself. Right before the strike, he was at the bottom of the driveway, standing still, arms to his side, and he was looking at and arguing with his main taunter, Gonsalves, when from behind, and even the witnesses who were lifelong friends of the victim, Mr. Russell, said that Mr. Russell came out of nowhere, ran up to Ridley and punched him in either the back or the side of the head, depending on what each witness saw. Ridley spun around, and what these witnesses saw was the two of them punching each other in the stomach. Of course, Mr. Ridley had the knife. The mental state that he had at this time was illustrated by what happened when his relative tried to stop the fight by grabbing him by his shoulders and pulling him away. Ridley turned around and stabbed him in the stomach, and it wasn't a light stab. His relative had a lacerated liver, his intestines were eviscerated, and he had major surgery. So this was, by all accounts, a voluntary manslaughter case. And had the jury properly understood that it was the Commonwealth's burden to prove beyond a reasonable doubt that there were no mitigating circumstances, there would have been such a verdict.
So this really goes back to at least your lead issue that the adolescent brain evidence should have come in, right?
Well, the adolescent brain evidence should have come in because he had a right to present a defense, he had a right to present witnesses, but my main argument is that the jury, by its note to the court, demonstrated that it misunderstood the jury instruction. It misunderstood that the burden of proof on the Commonwealth was to disprove mitigating circumstances, was to prove there were no mitigating circumstances.
But in this case, they had the recording of the instruction, right? And we've looked favorably upon doing that, right? Where judges send it in with the jurors. I shouldn't say we looked favorably upon it. We said they can do it.
Right, but this case is distinguished from that for a number of reasons. One is it wasn't just the jury saying, we're a little confused about the burden in voluntary manslaughter, and so can you just re-instruct us? And the judge says, well, go listen to my instructions. The jury misstated the law, and it was the law of the whole case. It was the whole defense. Even the judge understood the jury misstated the law. He said, well, their wording isn't even in accordance with my instructions. He said, it's proof that there were no mitigating circumstances, not that there were circumstances. That's the judge's own words. He understood it. And after he said that, he said, well, I suppose I need to re-instruct them on voluntary manslaughter. And then he later says, well, perhaps because mitigating circumstances are also mentioned in first-degree murder, I should re-instruct them on first-degree murder and voluntary manslaughter. Well, he didn't. And and not only did he say to the jury, just go back and listen to my instructions, he didn't even say, and go back and listen to my instructions on first-degree murder and voluntary manslaughter. And this type of sloppiness can't be acceptable in a first-degree murder case where Ridley now has a life without parole sentence when there was substantial evidence of mitigating circumstances. And the law is clear, both the U.S. Supreme Court, this court, when a jury misunderstands the instructions. They didn't just ask to be re-instructed, so you can't fall back on the case law that says, well, it's up to the judge's discretion whether he's going to re-instruct. The judge should have said, hold on, you misstated the law in this note. Let me tell you right now that it's the Commonwealth's burden to prove beyond a reasonable doubt there were no mitigating circumstances.
Let me ask you this, and I'm not sure which way this question cuts, but so I think the question is something along the lines, whether or not the Commonwealth has proven without reasonable doubt there were mitigating circumstances, something like that.
Right.
So, and you're right, obviously, that Judge Rufo did not tell them they had to listen to the recording.
Right, he was tepid. He says, well, if you think it'll help.
Well, okay, so, and then there's no re-instruction. So the reality of this situation, I don't know which way this cuts, is that it's very hard to say, to prove beyond reasonable doubt the lack of mitigating circumstances, and that it's the government's burden to prove it. We've gotten used to saying it, but there were a lot of reversals before we finally got the language right, where the judges got it wrong, where the lawyers got it wrong in closings. This is some juror coming in for jury duty, now on a piece of paper has to frame something that we've struggled for decades to get right. And I'm not sure which way that cuts, but it's a lot to expect they're going to be able to fastly write that out.
I think it cuts in favor of Mr. Ridley's argument. You're right, it's a very difficult concept to understand that the Commonwealth, after the defendant proves enough evidence of mitigating circumstances, the burden then shifts to the prosecution to prove a negative.
Any evidence.
To prove a negative beyond a reasonable doubt.
Right.
And so the fact that the jury came back with a question that misstates the law shows that they didn't understand it. I mean, and in a case like this, you can't just say, well, they probably just missed the word no. That can't be how first-degree murder trials are handled in this state. And the fact that the jury thought that the Commonwealth had to prove mitigating circumstances beyond a reasonable doubt is not so strange, because almost every other lesser-included offense, all those elements still have to be proven by the Commonwealth beyond a reasonable doubt. Say it's assault and battery, and the lesser include, assault and battery, dangerous weapon, and the lesser included assault and battery.
If he had re-instructed on mitigating circumstances and said, your note doesn't have it quite right, and then had done it, that would be okay.
Right. When they show their misunderstanding, the judge has no discretion. He has to correct their misunderstanding.
I mean, the reality is who knows? They may not have had a misunderstanding. It's just a very, very challenging thing for a layperson to write.
True, but we don't know, and we have 12 people, and maybe half of them thought that, you don't know, because what you do know, you have in black and white is their note where they misstate the law. You have a judge who understands, hey, they misstated the law, that's not my instruction, and who understood that they misstated that there were mitigating circumstances when in fact the law is there were no mitigating circumstances. So we have that the judge knew. And yet, after 10 days of trial and all these witnesses and all this work, the time wasn't even taken and the thoughtfulness wasn't even taken to instruct the jury correctly and correct their mistake on the record. I also, in keeping with how it's not so unheard of for them to think that the Commonwealth had to prove mitigating circumstances beyond a reasonable doubt, is even in this case, there were two separate assault and battery, dangerous weapons charges. One was intent and one was reckless, that the two different mens rea. So, of course, the reckless was lesser included, and each of them, the Commonwealth had to prove beyond a reasonable doubt. So it's understandable that the jury would still think that they would have to prove the mitigating circumstances beyond a reasonable doubt. And of course, that is so different than when you have all these mitigating circumstances here from witnesses who were the best friend of the victim, but even their evidence shows that all these mitigating circumstances that create voluntary manslaughter, that they were there and the Commonwealth had to prove that they were not there beyond a reasonable doubt when they clearly are there on the record. And so this was an error that it just cannot stand in a case like this.
Counsel, could you just make sure, because I'm a little bit confused by what you said.
Okay.
Didn't Judge Rufo tell them in response to go listen to my tape?
He said, go listen to my recording if you think it will help. He did not pinpoint them to where in his recording they should listen, even though he recognized that it was voluntary manslaughter and the burden of proof that they misunderstood. He didn't tell them to go there, and it was a long recording. We know how long these jury instructions are, particularly in first-degree murder. So it was not, and certainly more is required of a judge when the jury misstates the law, the only defense in
Where do we say that? In what case do we say that more is required? If you follow my math for a moment, there isn't any dispute, I don't think, that Judge Rufo properly instructed them at the close of the evidence.
Correct.
And that was on a recording.
Right.
Okay? This question comes back.
Right.
And as part of his response, however inadequate you might think it is, it encompassed, why don't you go back and listen to the recording of my charge? Okay?
Right.
Where do we say that that's not enough?
Okay.
What case do we say that?
This is Commonwealth versus Thomas. When a jury makes explicit its difficulties, a judge should clear them away with concrete accuracy. He didn't clear them away with concrete accuracy. He passively said, you can go back and listen to the recording if you think it will help. That was a quote from Bollenbach versus United States, where the jury came back clearly misunderstanding what the law of conspiracy to mail securities interstate, and I'm not going to get into the detail, but they by their question, it was clear they thought that if the person committed the crime just in one state, they could still be guilty. They kept saying, well, could he still be guilty if all he did was do it in the one state? And the answer would have been no, because it wasn't a federal crime if all he did. But the judge just kept saying, go listen to the instructions. And the U.S. Supreme Court said no when they're...
That really doesn't answer my question. What did we say that wasn't enough?
Well, it was in Commonwealth versus Thomas, it was the appeals court that quoted from Bollenbach. That and I would say that any time Bollenbach was quoted by this court, and there are, I don't know, hundreds of pages, well, I don't know hundreds, but probably over 100 pages of Shepard citations to that case. And so, Skinner, this is the Commonwealth versus Skinner, 408 Mass. 88. The jury had been struggling with the question of deliberate premeditation, and it said that given the jury's very specific question revealing a need for assistance in exploring the heart of the distinction between murder in the first and second degree, the judge's silence on premeditation fell short of providing a comprehensible standard to guide them. So the
judge wasn't silent here, though.
Right.
He referred them back to the instructions.
Yeah, but that's not curing their misunderstanding. It's
He also
passively.
told them to listen carefully, suggesting.
And even if he had said something, he would have just re-instructed, wouldn't he?
If he had, once the jury stated that they misunderstood the law, and the judge recognized that they misunderstood the law, the judge should have said just what he said. The jury would have been better off if they heard the discussion between the two counsel and the judge, because they would have heard the judge say, well, that statement isn't even in keeping with my instructions. It's the Commonwealth has to prove that there were no mitigating circumstances, not that there were mitigating circumstances. If the jury had heard that, that would have been better. But then when the jury came back, all that clarification that was going on among the lawyers and the judge was gone. The judge just, as I said, he passively said, even recognizing, well, I think I should, re-instruct them on voluntary manslaughter. He didn't do it. And this case just...
It's the only error is the word proven as opposed to disproven, right?
I'm sorry, excuse me?
The error is, the sentence would have been fine if it had said disproven, right? It disproven beyond, well, I guess, beyond reasonable doubt.
To prove that there were no mitigating circumstances beyond a reasonable doubt,
I
right?
guess
And you can't say that it was harmless in this case because of all the evidence of the mitigating circumstances. And the other errors, and I would like to just address something the Commonwealth brought up in the appeal, because all of the other issues, the one about the expert witness who was, of course, not going to testify that no 18-year-old could ever create the intent required for first-degree murder. It was, as the U.S. Supreme Court said in Roper, as any parent knows, the juvenile brain acts recklessly. They don't think before they act. And what his expert would have testified to, it's not just the juvenile brain, it's the 18-year-old brain also. So the jury could have known that, and he had a right to present this defense. And for the 33E argument, and also the prosecutor's misstatement of the law in closing, that goes to voluntary manslaughter too. The Commonwealth on Appeal had mentioned that Mr. Ridley had, and this only came out, that Mr. Ridley had shrugged when he was told that Mr. Russell may be dying in the street. What happened was when Joseph France said to Ridley, my friend may be dying in the street because of you, France said Ridley looked shocked and said, what are you talking about? Then the prosecutor said, well, what else did he do? And he said, well, nothing. He just said, what are you talking about? And he says, well, what else did you see? And he says, well, nothing. And he says, well, did you see anything more? He says, well, I don't know. I saw he wore a T-shirt. And then the prosecutor in a leading question said, did he shrug? And France said, yes. Then that's dropped. The prosecutor never even mentions it in closing argument. He didn't mention it as an element of extreme atrocity and cruelty. But the Commonwealth, I argue, because they're really bereft of evidence of extreme atrocity and cruelty, is trying to make much of this shrug. Well, the prosecutor didn't. Joseph France didn't make much of it. And frankly, I was surprised when I read it in the Commonwealth's brief, because if it was in my mind, I would have put it in the brief just...
But it's in evidence.
Huh?
But it's in evidence.
I agree, but the point is, it's a shrug cannot be considered the indifference that's required for extreme atrocity and cruelty. We don't even know what the shrug meant. Did he shrug when he said, what are you talking about? We don't know, and you certainly can't base that. If you have to prove beyond a reasonable doubt the element of indifference, you can't prove it by having the word coming out in a leading question by the prosecutor, the witness adopting it, and then it's dropped from the whole prosecution.
Quick question before you wrap up. Was the closing a request for a voluntary manslaughter verdict? Was that the closing?
Yes.
Okay, and I have no idea where this case is going to come out, but if it was error not to address the jury misstatement, I don't want to say misunderstanding, but misstatement of voluntary manslaughter. Under our case law, could we just enter a verdict of manslaughter?
Yes. Oh, this court's done it. Yes, absolutely. Right. Especially under 33E, it could. Yeah.
And in your research, did you, oh, your time's just about up, so I'll save the
Okay.
question. In your research on 33E cases, did you find any fact patterns similar to this one?
Yes, and
They're in your brief.
Yes, there were. Where there was multiple stab wounds, heat of passion, and even case where someone went and got a gun and came back to the situation, and this court lowered it to the voluntary. Yes, thank you.
Okay, thank you.
Okay, I was going to say if there are any more questions.
Attorney Nguyen.
Good morning. May it please the court, Mary Nguyen on behalf of the Commonwealth. With respect to the first issue, the law is clear that confusion must be expressed and it cannot be simply inferred. And I just wanted to quote the Lowy case that I cite in my brief for that proposition, and also for the proposition that you can't engage in the type of speculation that I would respectfully suggest my sister is engaging in with respect to the fourth statement made by this jury. And the quote is as follows: "Confusion cannot be simply inferred from a re-instruction request. It is not uncommon for jurors to request re-instruction, not because they are confused, but because they are proceeding conscientiously with deliberations and want to be reminded of an instruction." And I do point
But here-
Uh,
Here, that it's not just that I'm confused by the instruction, they actually misstate it, right? So they clearly are, they're either confused or they wrote it down wrong, right?
Correct. So in my brief, and I know Justice Lowy also commented on sort of, there's a distinction, I would suggest, between a misstatement and a misunderstanding. And I would also note that the trial judge and the two attorneys that were there in the courtroom while the evidence was being presented, no one interpreted that statement as a misunderstanding. Certainly, when we're talking about an abuse of discretion here, whether no other conscientious judge would respond to this juror statement in the fashion that Judge Rufo did, I suggest to you that there is not an abuse of discretion here. There was no error. This is a situation where the jury asked a question and where the judge directed the jury to re-listen to his instructions as agreed upon by both attorneys, and then to provide further clarification. And then the jury deliberated. Then they then asked to return the following day. They deliberated that morning, and then they returned a verdict. So they were told to listen to the instructions. I would ask Your Honors to look at the entire supplemental instruction. I know my sister does point out one line, but if you go back to the record, Justice Rufo indicates on multiple occasions, once saying, what I respectfully suggest, and this is why I did it, is that you take some time and you listen to the instructions on the audio tape. That's the first instance where he directed them to his original instructions in the recording. And then the quote that my sister states is, and then at the end of that first day, before they returned that morning, he says, "At this juncture, I'd ask you to go back and listen to the recording if that's helpful." And then the next day, he talks again about the recording of his instructions. So there's this instruction where he repeatedly directs them to listen to the original instruction that is not in dispute. And then there's a presumption, a legal presumption in the law that the jury here listened to the judge's directive to listen to these instructions.
So I'm not sure really it's a directive with the quotes that you have. I mean, this is a well-tried case, and the obviously on the other issue of O'Cara is not complied with on the expert, but this is an issue I'm frankly struggling with in this regard. The evidence warrants first or second degree murder, no doubt, but it's a case where the Commonwealth needs to really prove beyond a reasonable doubt the lack of mitigating circumstances. And I wouldn't be surprised at all if the jury just misstated that very complex concept, but we have no way to know. And the jury is not directed to listen. Why isn't that a substantial likelihood of miscarriage of justice?
So I understand Your Honor saying that it was not a directive. You might disagree sort of with.
No, if you think it's a directive, can convince me, because if they're told to go listen to it and the instruction is right, obviously when it was given and taped, then forget my question.
No, I'm just gonna have to defer to the record on that, and I guess it's a matter of interpretation of the judge's instructions, whether you look at it as a directive or as a suggestion.
I really would like help, though. I'm sincere about this. How do I interpret it as a directive?
So, I mean, that's the whole role, right, of a judge, is to provide instructions. Right. Here, he did that repeatedly. And so there's a legal presumption that they follow that instruction. Our jury system, this is a quote that I cited in my brief, is in many ways built on that assumption, on the structure that the judge provides the law. Here, he provided the instructions repeatedly. And then the jurors follow the law, and then the record supports this presumption, because this isn't a scenario where they ask this question, the judge tells them, go listen to the instructions, which is an instruction that both attorneys agreed upon, and then they come back with a verdict. They deliberated. There was sufficient time here. So the record supports that they did, in fact, follow that instruction to listen to the recording.
He does say, and what I respectfully suggest that this is what I did, and this is why I did it, is that you take some time and listen to the instructions on the audio tape, and don't tell me whether you have or not, because he doesn't want any back and forth. But our court monitor has given you an outline that refers you back to the time within the CD, so you can fast. I mean, he's clearly telling them to listen to it and how important these instructions are. I think it's fair to say he's directing them to, in response to their question, to listen to the original instructions. And the original instructions, don't they say twice? I mean, the judge actually, it may be the model, and again, I defer to my colleagues who gave those instructions regularly, but it looks like he says twice that you've got to disprove, he makes that you've got to prove no mitigating circumstances twice. He makes the point and then he repeats it, and I'm just looking at page 77 on your opposing counsel's brief where the instructions given it says it twice.
So, Justice Kafker, that's the way that I read the judge's instructions, that it was a directive, and I'm just looking at sort of where you quoted. So in addition to him saying, take some time and listen to the instructions, don't tell me whether you have or not, and then goes into some detail about what the court monitor has provided with respect to the audio, and then about the jury's ability to go back to certain sections that they want to listen to. He also provides that very important instruction that it's my instructions as a whole that are important. So all of my instructions are equally important to you, as I told you. And he repeatedly.
I don't know how much help that is, but look at page, is 77 the instruction? I'm just looking at, I think it's your sister's brief.
Are you looking at my sister's brief?
Is it your brief or hers? I have the instructions. It's your brief, maybe it's yours. On 77, is it your brief?
I believe that might be my brief.
The original jury instructions and final charge on voluntary manslaughter
Yes,
and mitigating circumstances. So, basically, he goes, therefore, if the Commonwealth, so a killing that would otherwise be murder is reduced to the lesser offense of voluntary manslaughter where the Commonwealth has failed to prove that there were no mitigating circumstances. Then he repeats the point. Therefore, if the Commonwealth proves all the requirement elements of murder but fails to prove beyond a reasonable doubt that there are no mitigating circumstances, you must not find the defendant guilty of murder, but you shall find the defendant guilty of voluntary manslaughter. That's the instruction, right?
Correct. That's
what he's telling them to go back and reread, right?
Correct.
Yeah, that's pretty clear, isn't it?
Yes, and there's no dispute that charge is proper in this case. And certainly, here, the judge reasonably chose to stand by those approved instructions rather than to assume the risk of unnecessary paraphrase, where I think one of the cases that my sister cites is where, unfortunately, the judge in that case did provide a supplemental instruction that was erroneous.
Counsel, could you also give a little bit of clarification, because I think Justice Kafker raised the issue, which was my issue with your sister's argument. Didn't he direct them specifically, I believe Justice Kafker read from the record, I don't have it in front of me, to say, here's where you can go back, the court reporter says, this is where you can go back to find what I said. I thought he did say that they were given some direction as to where to find it.
So I know, I can't recall on which day, he talks about it on both days, but the quote that Justice Kafker was reading, it says, but our court monitor has given you an outline that refers you back to the time within the CD so you can fast forward it.
Okay.
And then he talks about how you can quickly go to those sections that you want to listen to, and then
So
that's...
this wasn't just go back and listen to the tape.
No, they're provided with an outline which has the timestamps.
Okay, thank you.
Do we have that outline? in
I
the record?
believe my sister did include that in her record appendix, if I'm not misspeaking on that.
Thank you.
So, and also, with respect to, I just also wanted to add, there's also that presumption that's well known that there's a certain measure of jury sophistication, which is also presumed. Here, I don't,
That proving, disproving stuff, again, is just as Lowy talked about. We've got all these errors by smart trial judges, so I don't know how much we can rely on sophistication if they're not specifically directed to the right place, right?
but, as Justice Cypher did indicate, whether he spoke or he relied on the recording, which were proper instructions, they were in there. They were in those instructions, as you indicated, Justice Kafker, more than once with respect to that specific instruction on mitigation. If there are no other questions on this juror issue, I'd like to turn to the expert testimony, the exclusion of the expert testimony. I noticed that my sister in her reply brief indicated that the Fernandez case, which I cite to, is not applicable. I respectfully disagree. If you look at counsel's proffer, defense counsel's proffer during the motion hearing, he, in his proffer, indicates that he is seeking to enter general adolescent brain development, expert testimony on general adolescent brain development, and it was on the question of intent. He says, and I quote, this goes directly to whether or not a jury says, you know what, teenagers make stupid decisions. This is consistent with a stupid decision by a teenager lacking the intent to commit first or second degree murder. So here is explicit in counsel's proffer that he is seeking to enter in this general expert testimony on adolescent brain development as it going directly to the question of the defendant's intent with respect to murder, and therefore the law is clear under Fernandez and also under Okoro, if I'm pronouncing that case correctly, that there needs to be that additional evidence that ties this general expert testimony to the defendant, which is a critical piece missing here in this case. So there's simply no error here in the judge's exclusion without prejudice of the expert testimony, which counsel did not revisit, although Judge Rufo did welcome him to revisit. Are there any questions, any further questions on that issue?
No.
Okay.
How about the closing? How about, and think about it, reasonable provocation, anytime there was a fist fight, you would have the ability and the right to eviscerate someone, excuse me. I suggest not. Is that a statement of law?
I don't believe it is a statement of law. I think that it's a fair argument. He wasn't purporting to state the law, the prosecutor, when he made those two remarks, that remark that you indicated and also the second remark being challenged which is, quote, warranting the taking of life. If you, and I excerpted the relevant portions of the prosecutor's closing argument so that your honors could look at the entire closing in context. But here the prosecutor properly referred to the facts in evidence and also the fair inferences from those facts when he asked the jury to reject the defendant's claim that this single punch constituted adequate provocation. And certainly the prosecutor was entitled to cast the evidence in terms favorable to the Commonwealth, including the evidence suggesting the medical records and observations that investigators made of the defendant showing minimal injury, if you will, if any, caused by this alleged single punch that counsel was arguing was sufficient provocation. So I think.
But what about, I understand the second one, and I'm looking at them entirely in context, so I get the second one. But the first statement, reasonable provocation, anytime there was a fist fight, you would have the ability and the right to eviscerate someone. Is that making a comment beyond this case when you say anytime there was a fist fight? And making a comment of law?
I think the way he's saying, you know, essentially, let's think about this concept of reasonable provocation. A single punch here, you get punched. Does that constitute reasonable provocation in this case? I suggest to you, and then he goes into the evidence before and after. The evidence doesn't support, in this case, a single punch constituting reasonable provocation. And the prosecutor is saying, look, we know that he wasn't injured. And he goes into, and look, he didn't have any problem running after the fatal stabbing. Look at these minor scratches and superficial abrasions running through the woods half a mile. Look at all the evidence of the defendant's state of mind to go to the issue of whether he had the intent to kill in this case. So I don't think that it was the prosecutor here stating the law. Are there any other questions on closing? If there are no other questions, I would rest on my brief.